Our second story out front is deadly accident or brutal murder. So a Michigan man is under arrest tonight, facing second-degree murder charges after he shot a 19-year-old woman in the face. He is white, she was black. Renisha McBride was shot in the early morning hours of November 2nd on the front porch of Theodore Wafer's house. Now, Wafer says he thought she was trying to break in and that he accidentally shot her. McBride's family says she was looking for help after crashing her car. We want you to understand the whole story here because this is a fascinating question of race and justice in America. We begin the coverage out front tonight with Susan Candiotti.
Was the man who shot Renisha McBride in her face through his locked screen door in fear of his life? Not according to prosecutors, now charging Theodore Wafer with second-degree murder, manslaughter with intent but not malice, and a weapons count.
I am saying that we do not believe he acted in lawful self-defense.
On November 2nd, just a couple of hours before she was killed, McBride crashed her car. About 2 hours later, at 4:30 in the morning and several blocks from the accident scene, police say she appeared on Wafer's front porch where he fired a single shotgun blast through the locked screen door, killing the 19-year-old. McBride was drunk, nearly 3 times the legal limit in Michigan. Yet prosecutors say it did not play a role in charging Wafer.
We don't feel it's relevant to our charging decision at all in this case.
Prosecutors also rule out race playing a role. Police say Wafer told them his shotgun went off accidentally, that he heard noises and thought someone was breaking in. McBride's family wonders why he didn't just call police, that their daughter likely just wanted help from a stranger and wound up losing her life.
I can't imagine in my wildest dreams of what that man feared from her to shoot her in her face.
He shot her head off through a screen-locked door.
This monster that killed my daughter, I hope he spends the rest of his life in jail.
At his first court appearance after turning himself in, Wafer appeared stoic. He pleaded not guilty. He's described by his lawyers as an airport worker with the highest security clearance, who cares for his 81-year-old mother and his brother. Neighbors have described him as low-key and law-abiding. He now faces the legal fight of his life. Susan Candiotti, CNN, New York.
Now, under Michigan law, there's no duty to retreat when you're in your own home. But a person has to show they honestly and reasonably believed there was imminent danger of losing his or her life or suffering great bodily harm in order to claim self-defense. So here's the question. Do the charges add up? Because obviously, as we said, this happened on November 2nd. Here we are. Let's see. Out front tonight, Hostin and Danny Cevallos. They are criminal defense attorneys and CNN legal analysts. And Danny, let me start with you. The prosecutor in this case waited nearly 2 weeks to bring the charges. All right. They came after protests, national media attention. So to a certain degree, it might seem that there was pressure to satisfy the public. Bring charges because people demand there to be charges. So do you think this case warrants second-degree murder, or did public opinion play a role?
No, it doesn't warrant second-degree murder. This is a classic Castle Doctrine case. This isn't about stand your ground. It may not even really be about self-defense. In Michigan, the law is clear. There's a rebuttable presumption. In other words, the law will presume that if somebody is breaking into your house, that the defendant believes someone was breaking into his house, he has a reasonable fear that deadly force is about to be used against him. That's the law. It seems to me pretty clearly that under Michigan law, this case shouldn't have been brought, that it's an extension of Castle Doctrine, and that, just like you said, every American has a right to come to the door as long as they're within their own home with a firearm, like it or not.
All right, Sonny, the thing is, the Castle Doctrine simply means, defending your own home, that you have a right to do that. But when there are signs of forced entry, which there were no signs of in this case.
Exactly. And I mean, Danny couldn't be any more wrong in this. You have a man who is secure in his home when someone is knocking at the door. Then you need to call 911. You don't just open up the door, which is what he did, leaving the screen door locked, and open up with a deadly firearm. I mean, that is just ridiculous. It's not the Castle Doctrine at all. It's not stand your ground. It is second-degree murder. It is manslaughter. And I think that the government charged appropriately. We have to remember they did take at least 2 weeks to investigate. When the police first wanted to charge him and brought the case to the government, Kim Worthy, who I happen to know, we went to the same law school. She's a very thorough prosecutor, and she said, no, let's continue the investigation. Remember, they waited waited for the toxicology reports to come back before they actually charged this case. And I think it's wholly appropriate.
Danny, does it matter, though? And I mean, obviously, I know, you think that these charges are too aggressive, but the victim was drunk, the victim was high, she had blood on her, it's 4 o'clock in the morning. I mean, that could be scary, although this guy was a lot bigger than she was, and again, in the safety of his own home. But does her physical condition, is that relevant?
Well, it goes to whether or not the defendant, whether she behaved in a way that gave the defendant reason to believe that she was trying to get into the home. That's why those facts will be so critical. A lot of this other stuff is just window dressing, because despite what Sonny says, which is interesting from a coffeehouse discussion perspective, but under Michigan law, it's clear. If the defendant believes someone is trying to enter their home, that becomes either a home invasion situation or an entry situation, and under the law, there's a rebuttable presumption that the defendant believes that he was under lethal attack.
That's ridiculous. I mean, I didn't realize that we were in a coffee house, but the bottom line here, Aaron and Danny, is that the one thing I think that we're not talking about, which is sort of the elephant in the room, and no one wants to talk about it, is the role of race in this case. I mean, you're talking about Detroit, you're talking about a white man secure in his home, yet what does he do? He sees a 19-year-old black woman at his door, and he uses a firearm, and he shoots her in the face. And no one ever stands up and says, I'm afraid of black people. I'm a racist. I've never heard anyone say that. But to suggest that race doesn't play a role and did not play a role in this particular case, I think is ridiculous. It's something that we need to talk about when we talk about these types of cases, these castle doctrine cases, these stand your ground cases. I think this is very much so one of these sort of racial profiling cases that gets subsumed in the castle doctrine.
All right, well, thanks very much to both of you, and to all of you. Please weigh in. Let us know what you think, whether race played a role or whether the prosecutors are going too far under public pressure. We want your point of view as this case continues. Please tweet me at Aaron Burnett.